There we go. And today, Kerry and I are going to chat to you about a few topics that we thought were currently topical, and also sort of refreshers and useful kind of updates, and telling you what's sort of coming down the line. So as I mentioned, we're recording it. I'm sure you're all very adept now at using the Q&A function on your Zoom. So if you've got any questions on any of the topics as we're going along, just sort of drop them in the box and we will try and spot them and pick them up at the end of each section. And if not, then we'll try and catch up at the end. We'll aim to try and stick to an hour because I know that people sort of A, get zoomed out, and B, have other things to get off to do. So I'm going to kick off today. The first section, we're talking about firing and rehiring. I'll come back to that and what that means. Kerry's then going to do a bit of a roadmap to work. There's lots of roadmaps around at the moment, as we know, issued all over the place by governments and tribunals, and I'm sure businesses have their own roadmaps, but we're looking at getting back into work for those people who are currently working remotely and what that means for you. And also then just some new legislative changes, a few interesting topics, things that are being looked at, might be coming down the line. So hopefully that's a bit of a newsy bit at the end. So I will start off then. I'm going to talk about, as I said, firing and rehiring. What do I mean by this and why am I talking about it? Well, I'm sure that many of you will have seen headlines over the last few months, particularly relating to British gas engineers, when there was all sorts of furore around the idea that they were firing all of their engineers and then offering to rehire them on terms and conditions, particularly around pay, that were not as good as their current terms and conditions. So lots of headlines and lots of people speaking out about this practice. There were union demands to outlaw this practice, as they called it. There was a debate in Parliament in April about it. Various different politicians of different hues have come in and given their views on it. And also ACAS were asked to prepare a report about it. Now, it's a strategy or a means of varying terms and conditions of your workforce that has been around for some time. It is recognised as a fairly legitimate strategy, and we would normally talk about terminating and offering to re-engage employees rather than fire and rehire. So although the government haven't yet responded to ACAS's report, I think it's possibly fair to say that we're not suddenly going to see a sudden outlawing of it. I would be extremely surprised if that was the case, because in the right circumstances done properly, then, as I say, I think it is seen as a sort of legitimate strategy to use. And I do think that it's recognised that employers sometimes do need to make changes, organisational changes that are going to impact their employees. As I say, the key question is how you go about it. And that's the sort of refresher bit that I'm going to talk about today. I think it is still topical. Anecdotally, I would say, yes, we probably have seen more examples of looking to consult with employees and ultimately possibly having to terminate contracts and opt to re-engage as a result of the pandemic. Obviously, there's been a huge amount of pressure on businesses. Businesses have had to find different ways of coping, sometimes in very urgent circumstances with changes. And so as a consequence, we probably have seen a little bit more of this practice. I think some of the complaints, if you like, levelled at some businesses are that they've used it as a bit of an excuse to make changes that they knew were unpopular. Again, I make no comment, though. Those are the sort of different types of headlines that we see. So, as I say, as a strategy to implement changes in your employees' terms and conditions, it is fairly well recognised and well practiced. And what is it that you have to do in order to implement changes? Just to go really back to basics, the first thing to sort of flag is that clearly you have a contract with your employees. You have a binding contract with your employees. And generally speaking, if one of two parties wants to change the terms of a contract, then they have to get agreement. So the simple starting point is if you can agree changes with your employees, then that's what you should do. And frankly, that's the easiest and best way of approaching the issue. Alternatively, there might be occasions when one party to a contract, and in this case, it's more likely to be the employer, might decide, actually, I need to make this change, I'm going to make this change, and unilaterally impose that change on their employees. The difficulty there, of course, is that you're likely to be in breach of contract, as a consequence of which either you might have employees, particularly if it was a change that affected their pay, doing what we call stand and suing. So they might carry on working for you, but continue to protest about the change. And actually, if it's the sort of change that's reduced their pay, they might possibly go off to the Employment Tribunal and bring a claim for unlawful deductions from wages. Just one example. The third thing that you can do then, having tried to agree, but perhaps not succeeded in agreeing a change with your employees, is terminate and offer to re-engage. And that's this sort of fire and rehire practice, so say practice, that we're going to talk about today. Now, again, back to basics, there are a couple of key things to identify and to think about before you actually embark on trying to go through a process to put such a change in place. The first one is to ask yourself the question of whether or not the change that you want to make is contractual. Clearly, if you're looking at your employees' contract terms, and you see a very straightforward clause in there saying X, and you actually want to vary that, then you know that you are trying to make a contractual change. But sometimes there's a bit of a grey area. For example, ask yourself the question, well, is this not necessarily a term that's in the contract, but this is something that's in a policy or in a handbook? Now, on the one hand, you might think, well, that seems pretty straightforward. We think that's not contractual, so we don't actually need agreement to make that change. We can go ahead and do it. But sometimes there are terms in policies and handbooks that are, as the phrase would have it in a tribunal, apt to be incorporated. So you do have to make sure that you are looking at those grey areas. You do have to think about or take advice on whether or not, for example, policy changes or bonus schemes or redundancy schemes that you think are discretionary, are they genuinely discretionary, or are they likely to have become terms of the contract with your employees? So step one, is the change contractual? Step two is then asking yourselves whether actually the contract allows you to make the change. Is there a power to vary those terms in the contract? The most obvious example of this usually are mobility clauses. So all contracts are going to set out the place of work of your employees. And often in those clauses, you might reserve the right to change the place of work. Usually there'll be a bit of a caveat around it. Sometimes there'll be a sort of geographical area, or it will be sort of what's reasonable. But nonetheless, you might actually have, whether it's the mobility clause or another clause, of the power to vary those terms, in which case, if you are making a change, then you won't be in breach of contract if you make that change without agreement. But again, a caveat, you would still need to think about how you go about making the change, because what you don't want to do is say, well, look, the changes, the clause is there, it says that we can vary this, we are varying this, no notice, it happens tomorrow. In those sorts of circumstances, what you run the risk of is breaching the implied term of trust and confidence. You may have the power to vary, but the way you went about it on no notice wasn't really effective. So when it comes to looking at powers to vary, again, look at the explicit terms. Just how wide is it? Just what does it allow you to do? A mobility clause with an express power to vary might be one thing. If you're trying to rely on a general clause that says words to the effect, we reserve the right to vary these terms and conditions, and if we do, we'll let you know what we've done, when we've done it. That would be okay for minor changes, but our advice would usually be don't try and rely on the general power to vary just to impose a change. So having considered those two things and deciding that A, you need to go ahead, what should you do? The key thing really is consult. I'll come on to all the good reasons why, but obviously if you're trying to get your employees' agreement, then the best thing to do is to approach them and to talk to them about it. So consult with the employees themselves, or in some circumstances, consult with employee representatives, and I'll come back to that. You, as well as it being the right thing to do, if you think about the benefits of consulting, it means that A, you get a chance to set out and explain the reason why you need to make the change. Hopefully, if you gain their understanding as to the reason why you need to make the change, then you gain their agreement. So that's great. That's what you're hoping for. Also, it gives them an opportunity to make suggestions that you may not have thought of. And it may be that those suggestions, provided they still meet the business's aims for making the change, can be adopted and are less of a change, or the employees are more comfortable with those. So again, consulting with employees properly and meaningfully does give them an opportunity to understand, hopefully to be persuaded, and also to come up with other ideas that you may not have thought of. So definitely the need to consult is there. I mentioned employee reps. You may need to consider whether you need to carry out a process of collective consultation, so more formally under the Trade Union Labour Relations Consolidation Act. Now, I'm sure most of you familiar with the idea of collective consultation, particularly when it comes to large-scale redundancies. So if you're proposing to dismiss 20 or more employees within a 90-day period, then you will need to collectively consult either with a recognised trade union or with employee reps. That might be a standing body of employee reps, provided they've got the authority to represent employees in those types of collective consultation, or you might need to elect employee reps. Although most people are familiar with that applying to redundancies, the reason that it might also apply in these circumstances is because under the legislation, the wording is sort of slightly broader. It doesn't just stick to the word redundancy. So it does talk about a reason for dismissal that doesn't actually relate to the individual employees, their personal circumstances. So it's not a conduct or capability reason, for example. It's more of a sort of neutral reason. And that's why, because you're applying it to those 20 or more people, you have to collectively consult. So that's another very important thing to be aware of. Very important, because if you should have collectively consulted and failed to, then you're open to the risk of claims for protective awards, which is up to 90 days pay per employee. It's not about their financial losses, it's just a punitive award, really. So a very important thing to be aware of. So having decided to consult with your employees and hopefully gone through a sort of decent process, if you do get to the end of that process and there were some employees who haven't been won round, haven't agreed to the changes, you do terminate their contracts and offer to re-engage them, is that okay? Or are you still facing any risk? Well, potentially you are still facing any risk, because even though you're offering to re-engage employees on the new terms, nonetheless, you will have dismissed them. So any employee with more than 2 years service, of course, can bring an unfair dismissal claim. Your defence to that claim is likely to be relying on that broad catch-all fair reason in the Employment Rights Act of some other substantial reason. And there was a case many years ago, case of Hollister and the NFU, National Farmers Union, which did establish that a sound business reason requiring changes to terms and conditions would fall into that bracket of some other substantial reason. So by and large, that's where you are, and that's the sort of defence that you'll be able to mount. Now, there have been many cases, as I'm sure you would imagine over the years, where employees who have been dismissed in this way and haven't wanted to accept that offer of re-engagement have brought unfair dismissal claims. And so over time, there's a number of factors that have sort of developed through the case law that a tribunal will be looking at when they're assessing whether that was a fair or unfair dismissal. Because whilst on the one hand, yes, you might be able to put forward the reorganisation, etc., the business case as potentially a fair reason for dismissal, the tribunal has still got to go on and look at, which they do in all unfair dismissal cases, look at the reasonableness of that dismissal. So did your business case was relying on that as a reason to justify dismissal? Was that reasonable in all the circumstances of the case? So that those reasonableness factors, then what sort of things are the tribunal going to be looking at? Well, from the various cases, there are a number of things that we can sort of set out. One is that the tribunal are going to be weighing up and balancing the advantages and disadvantages to both employer and employee. So do the disadvantages to the employee, for example, if it's a cut in pay, outweigh the advantages to the employer of making this change according to their business needs. So there's a balance there. They'll also look at whether, obviously, the employer has carried out a meaningful consultation, whether the employer responded through that consultation reasonably to any objections raised by the employees, whether or not a majority of the employees accepted the change. Much easier to argue that if you've got a small cohort of 5% of a workforce holding out against a change to the shift pattern, for example, and 95% agreeing it, you're not going to be able to run a separate shift with just that 5%. So again, if the majority have accepted it, then that might weigh in the employer's favour. Sometimes it might even be that the trade union or employee reps have recommended to employees that they accept the change. So that might work in your favour. And then also whether you did look at any alternatives. If the employees came up to them, did you kind of consider them? Did you take them on board? So a meaningful consultation, all of those sorts of factors are going to go towards whether or not the tribunal will find that it was reasonable overall. I thought, because I know that often, certainly it's our experience when we have these breakfasts in our offices, a little bit of case law and what the cases have said always helps to sort of illustrate the point. So there's just, as I sort of wind up this section, there's just a few little cases that I'll run through or mention, just to give you a little flavour and a bit of an example. So the first case is a case called Dinham and William Hill, the book is. This was a case of a change to terms which did mean a reduction in pay. Mr. Dinham refused to sign up to the new terms because he felt the drop in pay was unfair. The employer, William Hill, they were essentially looking to make the changes and reorganising, really because they wanted consistency in terms and conditions. So presumably they had sort of differences across the board. They did carry out a relatively acceptable procedure. The tribunal found that the procedure adopted, which included informing consulting employees, was okay. But in this particular case, the finding was that it was unfair. And the reason it was unfair was because, notwithstanding that they were looking for that consistency, what they hadn't really done and what they couldn't really justify was that advantage-disadvantage balance. So in making the change, the tribunal decided that they hadn't really taken into account and they'd prioritised a need for consistency without thinking about an impact on particularly long-serving employees. So the disadvantage to the employees they found outweighed any advantage based on their business need, because they hadn't really pointed to any financial, sort of urgent financial circumstances or a reason that properly outweighed that disadvantage to the employees. So that was one case. The next case, Thorpe and Hayter Limited. This was where Mr. Thorpe was dismissed and re-engaged because of pension. So the employer wanted to make changes to pension. It was a defined benefit scheme. It was, there was a big black hole in there. It was in deficit. And the employee complained because he felt it was a fait accompli and that the consultation was meaningless. And the interesting thing about this case is that the tribunal said, whilst you must still consult, they did accept that there are going to be some circumstances when there really is only one option. And this was one of those circumstances, the impact on the employer and on existing members of that pension scheme, and with no really viable alternative being put on the table. Yes, there may well have only really been one, realistically, one option, but the consultation nonetheless went ahead and they decided that the dismissal was fair, despite the disadvantages to the claimant in this case. Quickly, the next one, Bosworth and Northampton Partnership Homes. This was a refusal to sign up to new terms, which resulted in an increase in hours and no extra pay. And here the tribunal found that it was unfair, mostly based on procedural failings. They didn't really investigate relevant queries raised by the employee in question. They had a fairly, what was called, sterile approach to the appeal process that couldn't have changed the decision. But what was really fatal to their defence was that, having put a time on when they wanted employees to indicate if they would accept the new terms, that having passed, they've nonetheless said to employees that if they, once dismissed, turned up for work the next day, they'd be deemed to have accepted the new terms and on they would go. This particular claimant didn't get that option, because when they dismissed him, they marched him off the premises, which slightly undermines the whole point of the process you're trying to go through, which is to offer to re-engage. They didn't really give him the option of re-engaging, despite saying at the outset that that's what they would do. So that's what shot them in the foot there. And then finally, I mentioned this one because I think it's possibly a bit of a Rolls Royce of these cases, a case called Pine and Bailey against B&Q, Pine Bailey against B&Q. And in this case, there were changes that impacted people's pay. So again, usually a pretty contentious issue. They were aimed at eliminating anomalies in pay and reward structure and sort of evening out. There were winners and losers. But the thing about this case, and the reason to mention it, is that the tribunal really was sort of full of praise for the process that was undertaken by B&Q. They accepted that they had good business reasons for wanting to simplify the pay structure, make it more transparent, as well as making it easier to recruit. There was a well thought out consultation process with both collective and individual consultation. It had led to some modifications of their original proposals in the employee's favour. And despite there being, as I said, those winners and losers, even though this claimant stood to lose out to some extent, he did retain some allowances, he would receive some compensation, and possibly the final sort of key was that the vast majority, over 99%, had accepted the proposals. So that also went in favour. So that is a little run through of some of the cases, and you can see the types of circumstance and the types of things that are taken into account. The last thing I will say is that do bear in mind that you might make some changes where an argument could be raised that it has a discriminatory effect, particularly if it's a policy that impacts on one group with a protected characteristic more than others. The obvious case, and there are cases on this, being where, for example, you're changing working hours and women with more childcare responsibilities, which is pretty much still accepted to be the case, maybe changing, but is at the moment still accepted to be the case, might struggle, say, with the new working hours, and so there's a disproportionate impact on that group. That gives rise to an indirect discrimination claim, which you still have a chance of defending if you can show the objective justification that you had a legitimate aim, and this was a proportionate means of achieving it. So they probably tie in with the business case and rationale you've put forward anyway, but just to be aware that you might have that extra sort of complexity in that sort of claim. And now I will hand over to Kerry, unless there are any questions. Have you spotted any, Kerry, that I could answer quickly? Yes.
There's one question, which is, can we have an email which references the cases? So
yes, absolutely. We normally tend to try and send out something after these talks, just to give you some of those kind of brief bullet point details. So I'll make sure that you get those case references. And I'll hand over to Kerry now.
Brilliant. Thank you, Kerry. So I'm going to talk to you about three things that are COVID related this morning. Sorry, everybody. I'm sure you've heard enough about COVID, but I think we need a recap on the return to work, as the roadmap is opening up, as Kerry says. So what's that going to have in store for employers? Number two, can you require employees to have a vaccine? And number three, how are tribunals dealing with cases concerning COVID? So first off, returning to the workplace. Well, as everyone knows, the current guidance is still, if you can work from home, then you must work from home. But we also know that on the horizon, fingers crossed, as of the 21st of June, we may see more of a return to normality going on. What will be normality is a matter of debate, actually, and a lot of businesses are currently thinking about what will be the new normal going forward in terms of their business. I've seen in the press that 80% of the top 50 companies are saying that they will be adopting a permanently hybrid approach to work, so combining working from home and going into the office. So returning to work, what does that mean? I know we've talked about it before, but it's worth a recap. First off, I would say that a couple of things to think about is perhaps think about allowing volunteers to be the first ones back in this summer, if you're not already back, and make sure that you're doing things to protect particularly vulnerable employees or those employees that have vulnerable people who live with them. What are the potential claims that we could be looking at if we don't get this right? So first off, there is if employees refuse to return to the workplace because they fear serious or imminent danger, then they're protected under sections 100 or 44 of the Employment Rights Act from detriments or dismissal because of that. The second type of claim that I can envisage is potentially whistleblowing claims. If people feel that you're not complying with health and safety requirements or government requirements about these sorts of things. Constructive unfair dismissal claims, either express terms in their contract or implied terms in terms of workplace safety and trust and confidence. And discrimination claims. I think, as we've seen in the last year, COVID has had an impact on lots of different people in lots of different ways, and there are certain groups that would be potentially more impacted by returning to the office than others, particularly those who are more vulnerable. So I suppose those are the claims. What are our 10 top tips to avoid those claims, or at least reduce the risk of them? The first one is follow the government safety guidelines. I know over the year that's been a full-time job, keeping abreast of what the government are currently saying, as it's been a fast-moving, developing area, but it's worth keeping abreast of those and following them. Number 2, workplace risk assessment. So it's all well and good following the government's guidance, but every workplace is different. So make sure you have a little think about how that applies in your specific circumstances. Number 3, communicate with employees. Make sure that they're aware of what it is that you're doing to make sure that they are safe in the workplace, and perhaps have an open dialogue. They might have ideas that you haven't thought of about how to make the workplace as COVID secure as possible. Number 4, train employees. So if you are implementing new health and safety procedures or rules of how you're going to operate in the workplace, make sure that employees actually know what they are and how to go about it. Number 5, discipline those that don't do it. So if they are aware of all of those rules and they're flagrantly disregarding them, then you need to be seen to be taking that very seriously for the benefit of all of the other staff. Number 6, provide PPE, hand washing facilities, masks, hand sanitizer, anything that you think that actually in your workplace that would help to make it COVID secure. Number 7, consider any issues that employees may have with public transport. If you know you've got a number of employees that come in on public transport, then maybe think about things like staggering the working day so that they don't have to all come in rush hour traffic or on the rush hour tubes. Number 8, potentially consider whether or not you should offer enhanced sick pay for those employees that are being asked to self-isolate. Reason being, if as an employer you allow employees into the workplace when they should be self-isolating, then you could be on the hook for that as an offence. So it's worth encouraging those employees to remain at home if they are on self-isolating. Of course, if they're able to and willing to, and it's possible, then you could get them to work from home when they're supposed to be self-isolating. And number 9, deal with all cases on a case-by-case basis. Like I said, COVID has an impact on lots of different people in lots of different ways. And so make sure that what you are considering is specific to that individual and their circumstances. And number 10, I suppose, prepare for an influx of flexible working requests. We've had over a year now of a lot of people having worked from home or different ways of working. They may have enjoyed that and want to continue with it. They may decide that actually their work-life balance would benefit in a different way. So prepare for those flexible working requests coming in. Dust off your flexible working request procedure. Make sure that your managers are aware of it and that they'll point them in the right direction if they are raised. So that is a quick canter through returning to the office. The next question that I've been asked to address is whether you can enforce employees to go and get the COVID jab. So I'm going to cut to the chase here. I would not recommend that you force employees to go and get the COVID jab. I think it's far better to encourage those employees that are able to go and get the jab to go and get it by letting them know about all of the benefits of the jab. You cannot physically march someone down to the local COVID vaccination centre and ask them to have the jab. It obviously is a matter of personal choice. But can you say that someone's employment is conditional upon them having had the jab? Well, in the press, you may have noticed that Pimlico plumbers, who are no stranger to our employment tribunal system, have said that they will make it a condition of employment, both for current and new employees, that they have the COVID jab. So in terms of new employees, I suppose it's a little bit easier. You can pop it into the employment contract. You can pop it on the job description that it is something that you require of the role. That's not going to negate potential discrimination arguments because they clearly apply to candidates as well as employees. But that would be easier than having to try and change the terms of all of your staff who are current staff. Potentially opening the door to constructive unfair dismissal claims and the like. So if you are going to have to consult with employees or justify a decision that all employees need to have a COVID vaccination, what is your business reason for it? I think it's really important to actually consider that in detail before you press ahead with making those requirements. Is it a health and safety reason? Is it that they are customer facing, or that they deal with a number of colleagues on a regular basis, that they're sat in close proximity to people and there's no way around it? Are they dealing with particularly vulnerable individuals on a regular basis? Clearly, if you've got a number of factors that make it more reasonable to be requesting that people go and get the jab, then that will be easier to be able to defend any potential claims. Or if you do get to the point where somebody is refusing to go and have the jab, then you may end up having to dismiss them if that's what your policy is going forward. And as Kerry said, you might be able to do that on some other substantial reason. But clearly it's better if you've had a good rationale and consulted with employees appropriately and taken into account their particular circumstances before forcing that through. What are the sort of risks that you're opening yourself up to if you are going to require employees to have the jab? Well, there are a number of reasons why employees may choose not to have the jab. Pregnancy, breastfeeding, anti-vaccination beliefs, which I don't know whether that would count as a philosophical belief under the regulation, under the Equality Act, disability, allergies, religious reasons or vegan reasons. So there's lots of different reasons why people might not be able to have the jab or willing to have the jab. And it does risk discrimination claims, constructive unfair dismissal claims and automatic unfair dismissal claims on health and safety grounds. So my advice, encourage rather than require. If you are deciding that as a business you do need to require employees to do it, then make sure you've got your rationale and that you deal with each employee on a case-by-case basis. So that's a quick canter through, should I require employees to have a jab? And my last little topic that I was going to cover today is how are tribunals dealing with cases concerning COVID? Well, spoiler alert, I am just going to step on Kerry's toes a little bit in her news roundup. The employment tribunals are clogged up at the moment. So I imagine that there are a number of COVID cases that are currently sitting on the shelves of the employment tribunal, waiting to be heard. But we have had one notable case that has filtered its way through the system, and that is the case of Rogers and Leeds laser cutting. And in that case, it concerns Section 100 of the Employment Rights Act, which gives employees protection from dismissal if they leave the workplace or take steps to prevent serious and imminent danger to themselves. So what were the facts of this case? So Mr. Rogers messaged his line manager on the 29th of March 2020 to say, well, I'm not going to be coming back into work at the moment until this lockdown eases, because I've got 2 children at home who are particularly vulnerable with sickle cell anemia. So I'm sorry, but I'm just not going to come in. A month later, he was dismissed. Now, Mr. Rogers didn't have 2 years service, so he couldn't bring an ordinary unfair dismissal claim, but he brought a claim for automatic unfair dismissal under Section 100 of the Employment Rights Act, relying upon the protection of employees who leave a work premises due to serious and imminent risk of danger. And the tribunal found that a reasonable belief in serious and imminent workplace danger had to be judged on what was known at the time of the acts that are at the heart of the matter. On the facts, they considered that such a belief could not be established, and so Section 100 was not engaged and the claimant's claim failed. In particular, they took into account that Mr. Rogers breached self-isolation guidance to drive a friend to hospital on the 30th of March, which is only the day after he texted his boss to say he wasn't going to come in because of the risk of serious and imminent danger. The second thing is he didn't actually mention any specific concerns about workplace danger in his message to his boss. He didn't show that there was any danger. In fact, at that point, the government's guidance was just to wash your hands and keep socially distanced. And that was what the employer was implementing at the time. And it also was critical of Mr. Rogers because he didn't take any steps to avert the danger or to raise concerns with his manager about any particular workplace danger before just deciding he wasn't going to turn up for work. So the tribunal also rejected Mr. Rogers' argument that COVID-19 itself created circumstances of serious and imminent workplace danger, regardless of what the employer was doing to implement safety procedures. And the tribunal said, well, we can't do that because if we accept that argument, then we are basically opening the door for every single employee to leave the workplace on the grounds of Section 100 of the Employment Rights Act, simply by virtue of there being a pandemic. So it's quite an interesting case because it's very fact specific, but it also gives an indicator of how these cases may be approached by the tribunal going forward. It's not binding, and so many cases may be heard and dealt with very differently. But it does highlight the importance of those 10 top tips that I spoke about at the beginning, because if you can show that you're doing all of the things that are reasonable to make sure that your premises are COVID secure, then you are going to make it much harder for employees to be able to argue that there is a risk of serious or imminent danger, which allows them to leave the workplace or not come back to work. So I think, like I said, this could well be the first of many cases that we see about COVID. But hopefully, with the top 10 tips that we've given you, you'll be well equipped to avoid any issues yourselves.
Thank you, Carey. I don't think there are any questions on those topics at the minute, so I'll crack on with the last section. But again, if anyone thinks of anything, you know, we'll pick some things up at the end. So really, this was just to talk a little bit about sort of what's going on, what's new, what's coming down the line. As Carey sort of flagged there, I was going to talk a little bit about employment tribunals and what's happening there. Continued delays and difficulties in getting matters listed, as Carey mentioned, particularly around London and the South East. That's where the backlog is most severe. Also, we're still relying on video and telephone hearings. The Tribunal have published their own roadmap. So we have a government roadmap for the country as a whole. We have a Tribunal roadmap in which they've basically made some changes and sort of set out what the sort of position is going to be over hearings. So whilst we might have some in-person hearings now, there's still going to be a default position really, particularly for preliminary hearings, case management directions, Short hearings, such as unlawful deduction from wages claims, etc., are likely to be by telephone or by video. I've had one full tribunal hearing by video virtually, which was interesting. We had to sort of set up a sort of tribunal room in our office. We had a witness box for the witnesses, etc. All very interesting. It can be done, but even the tribunals themselves still believe that justice is best served by in-person hearings. So we will get back to them, I think, but it will be some time, and some shorter hearings will remain by telephone and by video probably. The other significant thing that the Tribunal have done, though, is also, as part of their roadmap, they've created a virtual region. So at the moment, there are 10 regions all across England and Wales. So from sort of the southwest, south, London, east, Midlands, north, etc. Regional tribunals that sort of work together for all of the kind of cities and businesses on their patch. We now have a virtual region, so floating up above us in the cloud somewhere are legal officers and judges all working virtually. They're going to focus this, it only got going in April, they're going to focus it in the first instance on London and the South East to address that backlog, but basically cases from any region will ultimately be able to be pushed up to the virtual region as a means of trying to get through some of this backlog. There's also from April 16 new legal officers. So again, they're going to sit slightly, not just a sort of tribunal clerk and not a judge, but they can take some decisions that can be delegated by judges. And again, it's hoped that that might be more of a direct contact and might speed up the system a bit. So that's probably another good move. I think one observation from our point of view just about cases at the moment is that they are becoming ever more complex, and ever more they are being litigated in person. So a lot of claimants who aren't represented, bringing quite complicated cases. And there was a recent decision, a claim called Cox and Adecco, which talked about litigants in person. This was where a tribunal judge had actually struck out a claimant's claim because they hadn't properly sort of set it out, they hadn't really established their claim. And without going into huge detail, the EAT ultimately said, frankly, that the judge needed to try harder to identify the issues in the case and couldn't just expect an unrepresented litigant in person to be able to sort of point the judge to all of the documents and explain their case, etc., etc. They also significantly reminded everybody that both parties have a duty to comply with the overriding objective and assist the tribunal to understand the issues in the claim. And that means that the respondent's representative also has a duty to help the tribunal. So if the claimant aren't able to articulate their claim and sort of point to the relevant documents, but the respondent's representative is aware of where those relevant documents might be, then there's a bit more of an onus on the respondent's rep to help the judge. And of course, the judge themselves have got to make that effort to understand the claimant's claim. So whilst claimants are still meant to be setting out their claim, and no, it doesn't mean that if we're representing them as businesses, we are actually going to be advising the claimant, not at all. But there is an obligation to be sort of helping the tribunal rather than the claimant to understand the claim before it. So an interesting recent case and very relevant, I think, for us in a lot of the cases that we're seeing. There's been a recent report published talking still about tribunals by the Law Commission. Now, the Law Commission often go off and they do research and they look into particular issues of law to see what improvements could be made. Are there gaps? Is there any lack there? Is there anything that needs to be done? And have recently issued a report about employment tribunal hearing structures. And they've made a few recommendations, a couple of the sort of interesting ones. One was to widen breach of contract claims so that employees can bring these during their employment. And at the moment, breach of contract claims can only be brought by employees where they arise on termination of their employment. Also, they're talking about increasing the limit for those claims from the current £25,000 to £100,000. So again, these are just recommendations from the Law Commission at the moment. And that's probably to avoid some cases where you might have a claim over, a breach of contract for failure to pay notice pay. It's a high earner, it's more than 25,000, and rather than that person have to go off and issue two sets of proceedings for argument's sake, then they're talking about increasing that limit in the employment tribunal. The other thing they're talking about is extending the time limit, which I think possibly a few eyebrows might have shot up across the ether. So currently, as you'll know, the majority of employment tribunal claims have to be brought within 3 months, be that 3 months of dismissal or 3 months of any act of discrimination, etc. And they are talking now about extending that to, or the Law Commission is suggesting possibly extending that to 6 months, which, you know, there are arguments for and against. I think the difficulty for employers probably is that it's just going to extend that period of uncertainty. There are often occasions when you think, that maybe wasn't the best sort of parting of ways, and somebody wasn't very happy when they left the business for whatever reason. And you're normally kind of keeping an eye out, and at a certain point you think, well, you know, it doesn't look like there's a claim coming after all, great. Now at the moment, ACAS early conciliation already extends that 3 months period, so you can't breathe a sigh of relief immediately after 3 months. But extending it out to 6 months probably means, and if you take account of the current backlogs where sometimes claims are issued and not sent out to respondents for, we've seen a couple where it's maybe been 3 or 4 months, then it could mean that that period of certainty might spread anywhere between sort of 6 to 12 months. So possibly wouldn't necessarily be welcome. I think the only other downside really as well is that things move on quickly, and the further away you are from the actual acts and time of dismissal, more difficult it is to sort of get witness evidence, gather paperwork, maybe people have left. So I think there are pros and cons on that. As I say, they're part of a Law Commission report. So at the moment, it's not set in stone. The government will consider it. We may get a response. We may hear about whether or not they decide to adopt any of these changes in, say, 6 to 12 months, but that remains to be seen. Usual uplifts to tribunal awards. So the awards for injury to feelings for discrimination claims, as you'll know, there are 3 bands, lower, middle and upper, and they now go up regularly every year. There was a point when they jumped quite significantly and then sat there for a while. That's when the Vento bands really were established. But they're now set to go up incrementally every year. So currently, just for those of you who like to know, the lower band is 900 to 9,100. The middle band is 9,100 to 27,000, and the upper band is 27,400 to 45,600. So the middle and upper bands are pretty significant sums of money now for injury to feeling or potentially injury to feeling awards in discrimination claims. Changes to statutory maternity, sick pay, those sorts of things, tiny changes, 50p here and there, so not very significant. And redundancy pay, possibly still fairly topical, but redundancy pay, statutory redundancy pay rates have gone up to £544 is now the cap on a week's pay. So the maximum award is just over £16,000, 16,320 for statutory redundancy pay. And the cap on unfair dismissal is now approaching £89,500, or a year's salary if the year's salary is lower. So not all cases get anywhere near the cap, to be fair, but if they did, it's capped at £89,493. So the usual sort of stats. A couple of sort of date things to be aware of, a bit of a leap sideways for me to talk very quickly just about sort of right to work checks, kind of immigration things. One, right to work checks, you hopefully were aware that back in March 2020, they made a temporary adjustment so that you could essentially do sort of virtual right to work checks, scan documents, things like that. That was due to come to an end in May, but actually they've just pushed it out slightly, and it's been extended to the 20th of June. So the day before the next sort of roadmap change, possibly on the basis that if they lift the if you can work from home proviso, then obviously that might mean more people coming back into the workplace, and that might mean you can crack on and do the normal right to work checks and actually has to see original documents. So that's just a date to note. And the other date to note, which is scarily coming down the line very quickly, I can't quite believe that it's nearly the end of May, but at the end of June, it is the end of the grace period for any of your European workers who were in the country before the 31st of December and have the right to work here and have the right to apply for pre-settled or settled status. So if they haven't done so already, and hopefully you are all over this, but it's always worth flagging deadlines, that grace period comes to an end on the 30th of June. Anyone who's arrived since then, of course, they've got to have visas, as would any other overseas employee looking at the points-based system. So those are just a few dates and things to remember. Other things going on. One other thing to mention is a consultation that's open at the moment, underway in relation to post-termination restrictions. Now, this is where you've got an employee who's had access to your confidential information, has customer relationships, etc., and you don't want them going to work for a competitor, trying to solicit and deal with the customers they establish relationships with in your business. You don't want them using your confidential information in that new business. And sometimes you say, actually, you've got so much information that and know-how about our business that we don't want you working for a competitor for a period of X months. So that's what I always call the general non-compete. You just can't go and work for a competitor. Normally it has a sort of geographical restriction, etc. So what does this consultation looking at? Well, the reason this has come around, and query whether it might be different this time. As I say, it's been looked at before and no changes have been made. Everyone who's ever come across these tends to know that it's quite a tricky area, quite difficult to enforce things. You can, but you have to really get it right, etc., etc. The reason it's come around now is that the government are very keen to sort of unleash innovation, very keen to get the economy sort of, back on its feet and thundering away. And they don't want anything that might stifle competition, stifle people starting new businesses, taking on employees, etc., etc. So that's why we're having this current consultation. There are two proposals. One is just to outlaw non-compete clauses completely. So you couldn't just say you cannot go and work for a competitor for X period within X geographical area. Gone. You would still be able to, I understand, rely on things like you can't solicit clients that you've dealt with while with us, or you can't stop dealing with our clients or poach our employees. So those things you might still be able to use to protect your business. And obviously confidentiality clauses saying you're not allowed to take away and use our confidential information, etc. But that sort of rigid non-compete, one option is we will just outlaw it, no longer enforceable. The alternative option that's been put forward in this consultation is allowing non-compete clauses, but putting more safeguards around them. For example, if you are going to impose a non-compete clause on someone, you have to give them some form of compensation. So you will have to pay them. Now, that might feel slightly counterintuitive. You terminate their employment, but you carry on paying them because you won't let them go and work somewhere else. But that's one of the proposals. My thought on that proposal is that what you would probably and more likely might be more sensible to do is if you have a decent notice period, then rather than try and enforce and pay someone not to compete post-termination, you will put them on garden leave during their notice period. And that gives you that buffer so that they're out of the business, their knowledge of the business and what the current plans and so on are is growing stale. And at the end of that notice period of garden leave, then they can go off and they can work somewhere else. Now, as I say, they are only under consultation at the moment. The other sort of ideas around how you might sort of put some protections around the use of non-compete clauses is also to put a sort of maximum amount of time length of time they can last, other sort of transparency measures. But key ideas, rule it out completely, or query you might have to pay financial compensation, which I think in some ways might at least mean that employers very much focus on, do they really need this? What protection do they really need? Draft those clauses properly, make sure they're bespoke to the risk that really is represented by an employee. So it's an area to watch. I think if it's important for your business, it is an area to keep an eye on and a consultation to look at. I think, and there's sort of 5 minutes to go before the end. So unless there are any questions, I'm just going to have a look. There is a question about Pimlico plumbers and how have they fared implementing their policy of vaccination for all employees, or is it ongoing? I don't think we know the answer to that question. I don't think it's in the public domain. I don't know if Carey has any further insight.
I just had a little Google when I saw that question come up, and if I'm honest with you, I think that Pimlico plumbers liked the big splash at the beginning to say no jab, no job, this is our hardline approach, which went all over the press. But I think if they are being challenged on that, then they're keeping rather quiet about
Yeah, which is perhaps not surprising.
that.
So that actually more or less brings us to the end of our formal bit of the talk. I hope that amongst that there was something of interest for you. If anyone has got any questions and you haven't put them into the Q&A box now, please do get hold of us. As I say, I think everyone knows us, to be fair. I don't think there's anyone online who doesn't know us and probably doesn't already have our email address, but if not, you can find it on our website. And as per the request, we will send out within the next few days just a sort of brief summary of some of the key points, particularly things like cases that you might want to reference and carers' top tips, things like that. So we'll get that sent out to you. It's always strange not being able to see you all, but as I say, thank you very much for joining. I hope that we will at some point get back to being able to have these catch-ups over actual coffee and croissant or breakfast wherever we might be in one of our offices, because I think what we do miss, and I'm sure you miss it too, those who do come along to our breakfasts quite regularly, we miss actually the sort of debate and the discussion, and it's quite hard to do that on webinars with too many people, so we're sort of choosing not to at the moment, but it will be nice to get back and for you to be able to sort of share your thoughts on topics of interest, which is normally what we like to do, promote it and provoke a debate, really. But thank you very much for coming along. I hope that was helpful and useful, and we look forward to seeing or speaking to you again soon. Thanks very much, everybody.
Thank you.